Here.
Walking at 3:30, that's why it said.
Oh, okay.
They'll get here eventually, yeah.
Yeah, maybe before before we leave here to go debrief, we should probably decide what we should talk about on Monday, or at least what we should,
Bring.
yeah, what's the next proposals to bring? Did I go check on that?
I think we should. Maybe it was just maybe I only saw a glimpse, but I thought it was somebody from the team. I don't like the owl.
The owl was so much better. Like, look at this mess I've got around me, you know, just to get the same system set up.
The owl was pretty nice.
Yeah. It's nice as well when they're talking and they're talking garbage, it'll focus on them.
I know,
It's a
right?
nice video, you know?
Oh, wow. Zoomed in right on the face close up.
Yeah. What's
Was
your
it them in
response
there
to
or
this? And just zoom in.
Was it for something else going on in there?
Hmm?
Is there something else?
There is something else. on
Okay.
there.
Sorry.
Hey, no worries.
Must have just mistyped it in when I got your email, because you would give me the whole list of.
Right, yeah.
Thought I typed it incorrectly. Apparently I did not.
Yeah, 320 versus G320.
Yeah.
I went up to third floor as well. The only indication was there was another group in there. So I was like, well, that's not.
I had like a coffee bar set up. I'm like, I don't think so. Ken would have set up a coffee. I mean, maybe he did. I don't know.
Next time, you know, that's, yeah.
Sorry about that.
This should be our microphone for the day. And then the output, I can't move this, it's locked to the cart. So it's still
There you
gonna come
go.
up behind us, but.
You see my update, Tom?
What's that?
You saw my update last minute?
Did,
Okay,
I
great.
didn't realize G meant ground.
Yeah, I didn't. We were in the wrong place. So,
I've never been to school.
yeah, I haven't, I've never been down. You just have a reading, so. Just do me a favor and just read the very last. division of
You should be
that.
careful, Steve.
349. Slight adjustment.
I think Austin probably has that, or,
I can do this
Yeah,
pretty
yeah.
well. I've got it split screen, so I can do it pretty easily now.
okay, sweet.
You good with that?
Yeah, and I'm glad yeah, there's one part that's changed from what I just saw, so that's good. That you,
Well, no, that should be the exact version that I'd sent.
that part got to it, right?
Yeah,
That's good.
okay, all right, good. You want to start? You want me to start?
Or can you send us the electronic versions first so I can throw them?
Oh, yeah, I will in a second. The first thing I was actually hoping to do, if we could, sorry, I kind of want to just go over where we were in terms of who sent what to whom. It's like, so we get to keep track of it. Do you mind if we do that first?
Okay.
So this, and I just want to, there may be, we may need some corrections to this. So if we do, just go ahead and feel free to tell me, but I tried to go back through our notes and then through all of our emails to figure out like where we kind of are. Because I just want to kind of keep track of.
Yeah, we've got a couple times.
I think I made enough for everybody. So I think where, to kind of start on your side there, we heard, and again, this isn't binding, it's just to sort of just keep keep us abreast of what we have sort of in front of us and what we have behind us. The ones in green, you gave us the numbers, said you think you're gonna bring proposals that are relatively lighter or less intense. The yellow ones may be of medium intensity, and then the red ones are the ones that maybe will have some significant changes or could be longer sessions to work with those.
Right.
You've given us proposals on 11 and 15. In addition to giving us proposals on 3, 4, 5, and 17. We have given you proposals on 1, 2, 14, and 25. I think you verbally talked to us about 25, and we can talk about that one again today as well. And then we've got the list there of the ones that we haven't necessarily given you yet that we expect to. So again, there's nothing binding on this document. It's just so that for planning purposes, we can kind of look at, okay, what do we still have to talk about? What have we not addressed? You know, that kind of thing. So, is there anything on there that looks either?
That
Any
looks about
changes?
right.
Looks about right,
Yeah.
okay. And I can email that to you too, if it would be helpful.
Have we made a proposal on 5? I don't think so.
You guys haven't?
No.
That's okay, that's why we're. I thought I saw one, maybe I did not.
5 is in our intermediate category, so.
Okay.
Yeah.
Let me fix that.
14, those are, no, they only gave us 1 and 2 last time.
Yeah.
Yeah, so that's updated,
Today.
for what we're gonna be bringing
Okay,
you all
okay,
in just a second here, which I'm gonna start emailing to you right here. That one. There we go, all right. So let's start with,
So no, before we start.
Yeah.
I think you guys owe us an update about Article 10 ratification and implementation.
and unfortunately, I have the same update I had for you last time, which is I have no update.
Well, it's been 4 weeks since we informed you about
Yeah.
our ratification,
It
so
has been.
how can you not have any update? Are you in contact with the Board of Trustees? Have you recommended the tentative agreement to be ratified?
Obviously, I presented the information to them, absolutely.
And so how long does it take you to relay information back and forth between Board of Trustees? and
I've presented the information to them, Sikander, and I don't have an update for you. I don't know how else I can describe exactly
Do
what we
you
said.
have, you just have like some type of estimation when?
At this point, I don't.
So the last Board of Trustees meeting was after we did our ratification, and that wasn't, it wasn't even on the agenda for their meeting. The next
That's
meeting is
correct.
gonna be in December.
That's correct.
Does that mean that the next time it can only be ratified in December?
Not necessarily, and that's one of the reasons that I don't have an update for you is I am in touch with them about what are the possible ways in which we can get this done as soon as possible. And I've relayed that information to the people to whom I answer.
So, how often are you in contact with them? Like, are you consulting with them regularly?
Yeah, multiple times a week.
Okay, and so what do they say when you ask them?
They've received the information I give them. That's the way it works. I share the information with my boss and that's my job.
Do they give you a timeline about
If
when?
they gave me a timeline, I would give you the timeline.
Did you ask for a timeline?
Yes.
Okay,
They have
and
been,
they said we don't have a
they
timeline?
have been unable to give me a timeline right now. As we sit here right now, they are not able to give me one.
Why is that?
I don't know. I'm not part of that conversation.
Interesting. So I mean, like from our perspective, it doesn't
No, I-
reflect very,
I completely and totally understand. Again, back to your comment last time, I don't dispute the way you characterized it in terms of what you felt I said to you. I think that's a valid criticism of me. I think it's valid. And if I were you, I would feel very similarly.
Yeah, I mean, from our perspective, I mean, we're wondering what we're even, doing here at this table. Like, are we wasting our time? Are you like really bringing proposals that are representative of the views of the Board of Trustees? If you're, not able to, it's difficult for us to have any faith in that, right? I mean,
We've
you
got
understand.
4,000 people that we're told did get a raise around the first, and we knew we had to wait a little bit to get things ratified, but I mean, based
It's
off the
been a
math of
month.
how much you cost the proposal, we've got $10,000 a day that could be going to grad students to pay for bills and pay for food. And we know they're gonna get that money with back pay and
Right.
things, but money tomorrow doesn't pay for food today,
I
right?
acknowledge
And
that.
so, from our perspective of all the people we have to negotiate with, this is a ridiculous situation that we're both frankly stuck with, but we don't have any control besides venting to you guys and hoping for a little more pressure to get from the Board of Trustees, because we're not getting anything, and we're not getting anything from the Board of Trustees saying that they're even hearing us, So,
I understand and acknowledge that, and I wish I had more I could share with you right now, but unfortunately I don't. And I
I mean,
realize
are
that's
you-
not an acceptable answer.
Are you confident that they would ratify it if it were put up to a vote?
I know what I've recommended for them to do. I don't speak directly on behalf of individual votes. I mean, we could look back historically in terms of how many times there has been a recommended ratification and how times it hasn't been successful. I don't know if that's occurred in recent history. This is the first ratification I've been here since I've joined the university, but
I don't think they've ever not. ratified.
yeah. So
Do you guys have anything else to add here?
Just unfortunate situation, but
I can at least speak as a steward, right? I have people in my department who signed up for dues. And they're coming to me asking, what's happening with this? What's happening with this? If you told us October 1st, right? It makes us kind of
I
look bad.
I 100% acknowledge that, and I appreciate that it's unacceptable.
Yeah.
I appreciate that it's unacceptable. And I appreciate, again, back to your point, that I don't think you said anything that's unfair. I can't necessarily dispute the fact that you feel that I misled you. You feel that I didn't speak to you honestly. I mean, I appreciate and acknowledge those comments.
The proposal that was tentatively agreed to, did that go across their desk before the tentative agreement occurred?
I'm not sure I understand your question.
Did they see the proposal that was tentatively agreed to before we
signed it?
Oh, I honestly, I don't know who exactly looked at which document in advance.
But
But it was sent
We
to them.
talk in principles and parameters and rules and, interests. I'm not in direct communication with individual board members sharing them bargaining documents. That's not the way that it works on this side of the table.
Who do you talk to?
I talk to a member of cabinet, I talk to the provost who sits on cabinet and then communicates with them.
Okay.
Yeah, I'm not in direct communication with the board themselves.
So how do you make sure that like what you're bringing as proposals are representative of their views or are ultimately something that they might agree to?
That's the sharing. If that's my authority line, my authority line comes through the provost who sits on cabinet. I mean, I don't, and I mean, so there are times when I have interface with other members of the cabinet, but regularly, I mean, that's with whom I interface.
So would the provost say, this is something we would never agree to, this is something we would agree to?
Right. Yeah. I mean, I have a weekly staff meeting with the provost and I've met with him apart and away from that. If there is something, and yeah, that's where I draw my direction from. Yes.
It's like a little game of telephone, like he tells you one thing. and then-
Well, it's a large, I mean, obviously it's a large organization. It's not, it's a small, that doesn't mean it's acceptable for the situation we're in, but I don't have a direct line to every single person in upper management. I mean, it's just not the way it works.
Do you have like a subjective reading on what the delay is?
No.
Are you worried that they won't approve it?
I'm not.
Okay. See if I've received the proposals. Still haven't received them.
It would help if I hit send. I'm not good at doing more than one thing at a time. So you should be getting 4 that we're bringing to you today, 3, 4, 8, and 17. If you don't mind, we'd like to do 3 and 8 and then 17 and then 4, if that would be okay.
3, 4, 17, and then 8.
No, 3, 8, 17, and then 4.
Okay.
Why can't it send to your address? All the internet. Does its thing. So this is a counter to your presentation of Article 3. We verbally shared with you that we were, oh wait, I'll wait till you when the email shows up.
Yeah, you can keep talking.
Okay. So I just put a comment in here. You had wanted to remove the phrase or designee. We are not in favor of that deletion, but we are willing to agree to a minimum timeline. You had requested a timeline of 90 days when either party demands a consultation. And we think that's reasonable. We can accept that.
So, yeah, I mean, I guess we were not, fully aware at that time that, removing the designee portion would mean that, we cannot have consultations about more minor stuff like
Right.
grievances and whatnot. But, again, that was not the intention of our proposal last time. Our proposal was like, we would like to have a meeting with the
Right.
president. And we don't really agree in the sense that, you've never heard of any union that can meet with the president because it's literally in our contract.
Right. Bargaining or doing grievance work with the president. That's what I've.
No, yeah, that's not
Yeah.
what we were intending.
Yeah.
It was just more of a meeting, a conversation.
An opportunity to have a
Yeah.
conversation directly with the.
And so, I think, oh, sorry, I'm not even sharing my screen. So, our intention was not to get rid of, those
Right.
other kind of consultations. So what, I'll just tell you right now what our next proposal is likely to be is going to be, other specific rules about meeting with president, to ensure that it's not, a bargaining meeting or a
Okay.
meeting about grievances. Even, we're open to the idea that no policy outcome has to be the goal of the meeting.
Okay.
But
So-
we do feel like, the word the president is there,
Right.
it shouldn't be there just for show, right?
I got it.
So we do believe that we are owed a consultation if we request.
So I think maybe part of the concern that we have, and I think there's two things. One, I'm not sure we would necessarily agree to it being part of the contract. That the other part is living in this article, which is specifically talking about implementation and administration of the contract, because the word consultation in this context is specifically referring to how we administer and deal with the contract itself. If you're telling me, and I believe you when you say that that's not really the purpose of the meeting, and I'm not saying we would say yes, but I'm saying it would probably be easier to consider if it wasn't necessarily in this part of the contract. In other words, if you wanted it somewhere else, that you were requesting a meeting and outlined, to your point, what the purpose of the meeting was, and safeguards against this isn't what we're going to do. you know, obviously, as I've said to you before, we'll take a look at any proposal you all have.
Mhm.
But I can tell you specifically with regard to it being about these type of matters, there's just no way that it's gonna be okay. But if it has a different purpose, I'd be happy to see a proposal. Can't say we would necessarily agree to it, but I'd be happy to see a proposal in terms of what you're liking, what you'd like.
The word president is in this article.
Right.
So is that just for show? He just said that it would never be that.
Yeah, the way that our practice is, absolutely, it's not gonna happen. You guys are gonna wind up with a designate. You're not gonna wind up with a president on matters of implementation or administration of the contract. You guys are not gonna be meeting, I mean, I don't see it.
University actions affecting terms and conditions of employment or any other mutually agreeable matters, right? It's not just about the implementation of the contract.
Right.
So
Yeah.
the university takes, policy decisions,
Mhm.
right? And some of those are taken by the president, right?
Mhm.
And so, I think we should be able to have a conversation about that.
Yeah, I understand what you're asking for. I think I'm not 100% clear on what you had said before, which is, I think, going back to the last meeting, you had said you want an opportunity to sort of share your thoughts and your feelings and to hear you wanted to hear sort of strategic insights was one of the, I mean, not been the exact phrase.
Like
you used, but
vision.
Something
Yeah,
along,
vision
something
for
along
the-
those lines.
Yeah.
Okay,
Gain information about like what the future is, yeah.
right. And I think that is a fundamentally different situation than wanting to talk about like compensation bargaining. Like those are
Right.
two very, very different meetings.
Right.
Sure,
If that
yeah,
makes
no,
sense.
I don't
Yeah.
think we would be trying to bargain with the president.
Right.
Yeah.
But the future of our terms and conditions of employment is something that I think is a reasonable matter to have a conversation about.
Sure. I mean, well, like I said, we'll take a look at another counter if you want to put it in another article. We'd be happy to take a look at it.
Yeah.
All right. We can move on to number 8. Sorry about number 8.
Sure.
All right, so I don't think there's any changes on the front. It's all in the back. So here is our interest here is down in F. F is we removed your removal, meaning we kind of went back to we would prefer the current contract language, that it being a second semester of employment, especially because I think that is consistent, and I'll defer to Robert, but I think that's across the organization. I don't think there's any group that has access to this type of leave within the first certain time frame. I don't know if it says semester in every agreement, but I know there's a timeline that must be accomplished before you'll be eligible.
That's correct.
With respect to the unpaid leave itself, the red should be, Sikander, I'm using the word, should be what you had sent in your previous version. So the blue would be my revisions to your revisions, if that makes sense.
Okay.
So what we're looking at here is going from, we had previously recommended 6, we're now saying, what about 8? But we're not really interested in a second bite at the apple. In other words, what we're saying is, okay, so the increment, we're okay with a longer increment as opposed to a second increment. And part of it has to do with just the administration of a rolling calendar. The administration of a rolling calendar is very, very difficult because it's individual to every person. And every time they come forward, you have to do a new calculation of exactly when did you take your leave? When are you eligible? How much time do you have left? So on and so forth. And that it becomes not only a significant administrative burden. However, the other thing is, like I said, we would like to see if the 8 weeks would be enough. We don't know if there's a difference between one or another time of year. We kind of thought a little bit about making it anchored into the semester, something along the lines of, if the leave exceeds the end of a semester, it would be to the end of the second semester. But it also created another administrative trouble of now that's another rolling calendar that we have to try to figure out and make sure that is fair. What if somebody goes 2 days into the semester? Do they get the entire semester? Because obviously there's a staffing backfill that we have to consider. If you're out on leave, if you're teaching or provide, it's a little bit easier on research because you can normally work that out with your supervisor, advisor, lab manager.
Right.
It's really probably more of an issue for those that have a teaching assignment. But so anyway, that's where we are on, we left C alone, that's on D. You know, and then, so the end of the term in which the leave started, again, it creates a sort of a runway. From the starting point, not the ending point, but the starting point. In other words, if you go on leave at the beginning of a term and your 8 weeks are up, but you're still not ready to come back, maybe we can give you until the end of that term without guaranteeing it to be, what would that be, 16 weeks or 17 weeks, without putting a week guarantee on it and saying, look, at least in the term that you started it, if you request it, we will consider extending it for the entirety of that term. So
I see, okay.
that's the intention. We didn't want to guarantee it for a certain number of weeks.
Did someone apply for a second leave on the second term immediately afterwards? Meaning they did the 8 weeks in one term. You don't want to do the rollover period,
Mhm.
but the following term, they request a second unpaid leave immediately.
Hang on, let me think about your question and look back through what we have here. Based on your question, I don't think there's anything in this language that would preclude them from making that request.
I wasn't saying either.
Yeah, I don't think there's anything that would specifically say you can't even request that. And to some extent, I think there's not really a problem because I think the way that it is now, we have pretty broad discretion in terms of approving it or not. So, I mean, I don't see that necessarily as an issue. I don't know, Robert, if you have an opinion on that.
Yeah, it's not a shall, it's a request, right? So.
So, I mean, about this requirement that a GA must be in their second semester, in order to be eligible for paid leave. So, I mean, what are they supposed to do if they, fall seriously ill, like in their first semester?
Yeah, I think they're in a tough spot. I mean, I'm not gonna make it sound like it's any easier than it won't be. I mean, it's difficult. You take a new job and then you get seriously ill. If you're not eligible for some of the more robust leave benefits, yeah, it's a terrible position to be in.
So-
I'm not gonna sugarcoat that.
Yeah, right. So, I mean, for example, in the faculty contract, for example, like what is the provision there?
Faculty members will have legitimate reasons to take leave, shall not be penalized. The duration of such a leave may be from a few hours to a year or more. Leaves include paid time off, approved workers' comp. I mean, it's a pretty lengthy article. What specific
What
part
is
do you
like
wanna know?
The minimum
yeah,
time when the benefits kick in, when they're
Yeah.
allowed to take leave.
Oh, I gotcha.
Yeah.
See, this is dependent on them first using the family medical literature.
Well, under FMLA, you have to work a year
Right.
before you get eligible for that
Yeah.
protected leave. And there's a certain amount of hours too.
So you have a year
Okay,
at
so-
FMLA first and then like paid leave through the contract?
So for the, so they have a paid parental leave program, which is a
Right.
little bit different.
Okay.
The period of the parental leave shall be determined by the faculty member in consultation with the university. Faculty members should be provided up to 8 weeks of paid parental leave for the birth or adoption of a child or initial placement of a child in the foster care of the employee. They can use their personal accrued leave. Can't exceed 6 calendar months. For faculty within the first 12 months of employment, they may use 8 weeks of advanced leave if they have fewer than 320 hours of accrued paid time off. Faculty members are immediately eligible for these paid parental leave benefits
For parental.
for parental leave.
so sorry,
That covers part of ours, because the first thing here is the birth of a child, so.
Right. But that's more narrowly, their
Right,
contract
'cause
is
they
much
get
more narrowly
FMLA.
construed.
Yeah.
Yeah.
Correct.
okay, and so, I mean, correct me if I'm wrong, in the article for paid leave, that language is on a rolling calendar, correct?
In your contract or their contract?
In our contract,
In your contract.
it says paid leave during any 12-month period.
Right.
So that is a rolling
During any
calendar.
12-month period. Okay, yeah.
So, I mean,
Well, it's on the front right here.
Yeah.
Yeah, okay.
Yeah, but this, keep in mind that F is not, that's not language that we're proposing this time. That's language that was already in the contract.
no, we understand.
Oh, okay.
Yeah, no, I mean, now I'm talking about a different point.
Okay.
About the rolling calendar point.
Right.
Unpaid leave.
Right.
So how is it so that much more of an administrative burden if you're already doing it for that? For the paid leave?
About making them eligible sooner or about tracking the rolling calendar?
About tracking the rolling calendar.
Yeah, I mean, it's a burden. I'm not saying it's more of a burden or less of a burden than
Would
other
you-
things we're responsible for doing.
Would you be amenable to maybe for the first semester allowing less paid time off, but still allowing a little bit, and then maybe they accrue it across getting another semester?
So I think,
We're
Or
going,
it's like it's the,
we're going back and forth about two separate things.
Yeah, I know, sorry.
I'm having a little bit of trouble following.
Let's stick with, the rolling calendar issue. first.
Yeah,
Okay, so in what we removed in D,
Mhm,
okay.
yeah, that's right.
So, I mean, I think to Jake's point, if I add this correctly, there's actually no prohibition from you requesting it again based on the way we rewrote it.
Okay,
So, in other words, the statement implies there's a limit of 2 times in a 12-month calendar. By removing the statement entirely, I don't read it as actually saying there's any particular limit. Which is kind of the way we rewrote it. So I think it sort of solves the problem of having to track because we accentuated the fact that it's at our discretion. And there's not a particular, I mean, that's the way that the intention was when we wrote it, right, Robert? I mean, that's how you're reading it too.
Right.
So there's nothing that says you can't reapply in the 12-month period, like that whole part's gone.
Mhm.
You're not guaranteed it,
Right.
but there's not a prohibition of even applying.
So anything else on that before we talk about the first semester or second semester thing?
no, I think we're good.
Okay, did you want to do yours first? I had something to ask about it too.
yeah, I was just gonna ask like, because yeah, obviously there's an issue with this allowing paid leave like right in the first semester, but maybe it's because it's 8 weeks, maybe too much, like would you be amenable to having less paid leave that gets accrued over another semester or something like that? Cause I'm not really sure why it's why faculty, at least for parental leave, can immediately use parental leave, but for us, that's not possible. Like, I'm just not understanding why.
Yeah, I think for us to consider that, we would probably have to completely reconstitute and much more narrowly construe this, whereas this is more of a blanket usage. Because that applies very narrowly to it only applies to that component. Am I correct, Robert? It doesn't apply to any of the other uses of the leave. It's only that.
So you would almost have to break out that.
What are the other leave, kind of qualifying events for the faculty paid leave?
I think otherwise it's relatively similar. I mean. Back into it, I just had it open. So part of it is the fact that to access at least one of it, they have to first actually take you can extend the medical leave as an unpaid leave, but you first have to take the medical leave. I think that's one of the components. Because it says at the end of the approved parental leave, a faculty member may request a part-time leave for up to a year. I mean, it's not like a 1-for-1 seconder. There is a whole bunch of different, very nuanced categories in their contract that don't exist in yours. So
Okay.
I don't know how.
We'll have
best
to
to-
take, we'll take a look.
Yeah,
at it.
I don't know how best to answer your question
That's fine.
accurately.
That's fine.
I mean, if you want to look at, it's in their Article 21. I have no problem emailing it to you for consideration. I mean, there's a whole bunch of different swinging doors about contingencies and timelines and stuff.
Okay. Jacob, you want to ask your question?
That's all right.
I can offer quickly, we had, like, as a steward, I was reached out to by a graduate coordinator who had a student in their first semester who was about to give birth, and they had no idea how to handle the situation. And I'm honestly not sure what happened. It was outside of my department. This person who trusted me, like, reached out to me, but like. The fate of like real people is on the line,
Mhm.
like, and this has already happened. And this is like, that situation was parental leave.
Right.
And so, like, we need to solve this somehow.
I got it. I mean, I understand what you're saying. I think that there's, FMLA administration, which this is not, continues to be a very difficult matter. I mean, as you know, just in the broader sense, how to deal with parental leave as a community, as a country, as a state. I mean, this continues to loom large in the public discourse. I don't disagree that it creates problems for individuals. I don't think in your situation, the contract wasn't administered appropriately necessarily, but I do recognize that if you are about to be a new parent and you are starting a new job, there are not the protections that there would be had you been an employee for, say, 3 years before that happened. I mean, I'm not going to say that those two people come to that situation equally benefited, because they certainly don't.
Yeah, we
Yeah.
just have an interest in trying to find something for them.
I
and to
acknowledge
define
that.
it for them at the very least.
Yeah,
Because we went back and forth, well, I think it's up to your discretion, well, I don't know, what is the contract, like, it was so confusing, and the whole time this person was stressed, obviously.
sure. No, I acknowledge that. I mean, I think that there's no way based on the nature of your contracts that you could ever qualify from a numbers perspective for FML. Like, there's just no way. Whether or not we would be able to do something different than the way it is currently right now. I mean, I think if you have some more nuanced ideas or proposals, I mean, we'll certainly look at them. But I think as of right now, I mean, our best attempt to modify the benefit is what we've sort of presented you with here right now.
So what, maybe I just missed it, but so how come offering leave in the first semester is just not, it's not really agreeable to that? Like, did I miss the?
No, I mean, I think in general, I think most employers, the last thing that they're interested in is having somebody come on board and then immediately leave and we pay for them to be separated from their work. I mean, I don't think it's any more complicated than that, to be perfectly honest.
So financially,
Well, I think not just financially, but it also prevents all of the normal processes that a brand new employee would typically have, because anything that they would be engaging in, I mean, your first, typically, depending on your position and your job, your first 6 months of a new position are typically very different than every subsequent 6-month period or year period after that. You're acclimatizing yourself to the specifics of your work, everything from how every process operates, all the people you have to interact with and meet. What is the general cycle of your job and responsibilities? And if that is disrupted in many respects, just in a general sort of, not scientific data speaking, but just in a general sense, you're going to still have to do that same acculturation. You're now just going to do it as a 1-year employee, as opposed to the normal period of you start a new job and you learn sort of the way of the world, so to speak. So I don't think it's any more complicated than that. And I realize that sounds like maybe a cold business answer, but I mean, I think that's the answer.
I just don't see the distinction there. I mean, like, if you are in your second semester and then you take 8 weeks of leave, when you get back from your 8 weeks of leave, you
Mhm.
need to like do what you weren't doing while you were on leave. You know what I mean? Like, the work piles up while you're on leave. So if it's your first semester work or your second semester work or whatever, seems like you have to do it when you get back.
But will it? See, I would argue that if you have somebody who's brand new and starts a position and immediately goes on leave, it's very position dependent, but I would argue that in most cases, I don't think there could be very little left for that person when they return, and they're going to start when they get back. I mean, I think there's a practical limitation. Now, again, there's a big difference. And now speaking sort of hypotheticals, if you pull a lever on a factory that makes a particular widget, you're 100% right. Like, or people can easily take it on. But the nature of the work at the university is so complicated and nuanced, and in some places so specific that you could be right. It could just be sitting there. Nobody else could be doing it. But I just think in general, and I don't think we're alone in saying this, I think most employers really aren't interested in giving very robust leave benefits within the first 6 months of, I don't think we're an unusual employer in that interest.
I think because it's not regulated. Paid leave, not required by federal law, it's not required by state law. So companies and organizations have flexibility, they make decisions and they make eligibility requirements because they can, it's their policy. And so that's a decision that was made institutionally. I think you're making valid points, but at some point they have to say, this is the eligibility. This is how we
Right.
apply it.
And I think we understand that, but also the nature of this work too, unless somebody's being hired on for like, and they're immediately like need to like teach a class or like be a TA, like obviously that would be difficult if they come on to take on this responsibility and then go out for 8 weeks. But a lot of people coming on just doing research, usually research takes a long time.
Mhm.
And unless they're being brought on to immediately finish a project that like needs to be finished for like a grant or something, usually you can take that time off and still be able to come back to the project. There should still be work available for research.
Right.
I think really, unless it's TAs, I mean, I don't think I really agree with that. There's just gonna be no work, or if the work's gonna be done, or, you know, coming on right on as the first semester. 'Cause usually research, it's always rolling. There's always things to
Right.
do. So
I don't,
I'm not sure why that would be.
Well, the TA can't do the work while they're gone. Somebody else
Well,
has to do it.
Right,
Right.
but usually, I mean, do people really, when they're immediately hired, do they start as a TA right away?
Yes.
Yeah, in my
And I
department,
can tell
For
you
other
this student
departments,
that I'm
not really
talking
for
about
mine, okay.
Was a TA,
Okay.
but
again, I don't see the distinction because if you are a TA and you're employed that way, you're expected to teach a class in your second semester too. Nobody is planning for their employee to take 8 weeks, but have enough employees that you can cover when someone needs it. And the same thing with research. If there's like a deadline that first semester, there could be a deadline the second semester. I don't see the distinction there. I do understand what you're saying, that essentially university makes the rules, and whether it's financial or strategic as far as orientations, we kind of have to go with that. But I guess the point that, I mean, in parental leave in particular, that is kind of hitting against like social justice in a way. And I imagine that's why there is carve outs in the contract. So I feel like maybe that is, I can understand if a, you know, parent dies, family member, or a serious health condition, if you want to draw the line there, but it seems like the first 3 under A would be important to make a carve out for, not be treating students differently. It's not students, graduate assistants.
So I think we've made our points. I mean, the reason why we struck that out in our last proposal is because we know of actual cases where this
Sure.
has happened, and we want to address that, right? And we also understand that there's all kinds of, you know, complications on your end, and, you know, clearly there's, you know, department to department, you know, there are totally different ways about how things are done. So I think we'll, come back with a proposal that's more specific and kind of tries to deal with those details. But again, it's something that, like, this is not something we just did like randomly. It's
I
something that-
don't think
yeah.
you were flipping.
Yeah,
I don't think you just, I don't think we think that at all, Sikander. I don't want you to think that we just think that you're just throwing stuff out the wall. I don't think that's the case. I would point out, however, that with the limitations that we put in 8.4, you know, in those cases, and I realize this doesn't necessarily help them, but in terms of providing them an option, you know, 8.4 would be able to be used.
Sure.
So, I mean,
yeah, which
No,
didn't
we get
exist at that time. but
Correct.
Would now.
correct. So, I mean, there is a path where it's not financially secure,
Right.
but there is a pathway that would enable them to do it and not immediately be separated for like job abandonment. So it's a little bit of a middle position, not a financially stable middle position, but there is a position in terms of protecting their job.
A middle position for people who can afford it, so.
I would argue no one, right? If you're having a newborn baby and you're a graduate assistant, I don't know. That would be very, very.
I think it'd be a limited
familial
number,
specific
yeah.
to Be able to do that, I don't know. Anyone who did, but yeah.
All right, so that's 8. Ready to talk about 17?
Yes.
3, 8. 17. This should be the same as the last one in terms of the red is, we believe, what was in there already, and the blue should be our changes. So on 17.1, the only thing that we wanted to add to make it more clear was that consistent with the requirements of the law, which it may have already been implied, but we want it to be explicitly stated. And then in 17.6, we are willing to put in here that the university shall include a statement on all future letters of appointment for position of the bargaining agent recognized bargaining. Now, part of that is already contained within Article 4, which we can talk about in a minute.
Sure.
But and shall include a website address where a prospective employee can learn more about the organization. Should GAU cease to be the recognized bargaining agent for the bargaining unit, the university shall cease including the notification of representation and the website address. So the specific stuff about the dues and giving you a direct link to your pay dues website and all that kind of stuff, we're just not going to be able to. We're not going to be able to agree to that. With regard to 17.7, I know it's crossed out, but I included the comment here, meaning, and we kind of talked about this at the last session. We think that we can basically accomplish the same thing by putting it actually in Article 25 and basically agreeing to, when we get to that one, for the 2024-25 academic year, the parties agree to reopen negotiations for Article 17. In other words, even though we typically wouldn't talk about Article 17, because it's going to take at least that long, probably,
Right.
for a lot of the court cases to be resolved.
I agree.
And, we'll just agree to reopen that. You guys wouldn't have to convince us to reopen it. We would agree in advance. We'll reopen it for, negotiation, even though it wouldn't be the right timeline.
Right.
So I think that's kind of where we are. I realize that's not everything that you all had wanted in there, but a couple of the things I'll just point out. Initially we had said we wanted to kind of strike the whole thing. I think that with the limitations that we've added in 17.1 and again, 17, again, not what we put in 17.7, but by agreeing to reopen it as soon as, next year's reopener, we believe it provides reasonable protection for you all about this particular item. Especially because as it stands right now, it's no secret, we're not collecting them right now.
Right.
If we were collecting them right now and we were on a precipice of saying, hey, on November 1st, we're going to stop.
Yeah.
But that ship has kind of already sailed. So, I think the university is interested in continuing to engage with you on this topic. We realize it's a topic that is currently being, decided by courts, maybe courts of appeals. Who knows who all is going to ultimately decide? There may be new legislation that comes in this legislative session about it. So, I think we're interested in continuing to talk with you about the topic to the extent we're permitted to under the law.
So, I'll just start off by saying that I think this is a significant improvement from the previous proposals that we've seen. So we're thankful for that.
Thank you. Okay.
Could you go into a little more about why kind of the specifically notifying about e-dues is not acceptable?
Yeah, so the university really wants to be extremely careful about being construed as assisting you with organizing. I think we sent it to you before. It's actually the unfair labor statute practice, which specifically prohibits the university or any public employer from engaging in organizing activities.
Right.
We're supposed to be basically completely neutral. We can't promote them. We also can't detract from them. Like just the same way that we can't say, hey, you should join the union. We also can't say, better not join the union. We have to effectively stay out of that conversation to the greatest extent possible. And we believe that by being specific about pointing you, not just about, hey, there's a recognized bargaining agent for this position. This is how you can get in touch with them, or this is the information about them. Feel free to avail yourself of what they have available, and saying specifically, this is how you pay dues to this organization. We are concerned legally that could be construed as an encouragement for them to join and actually provide money to the organization, which we believe is beyond what we're allowed to do.
Okay. Would just adding in something that in order to join the union, like we don't do payroll deductions for union dues. It's like adding like a line about that, since that's usually common in other unions and things like that. So at least it was before.
I think it's a reasonable question. Here's what I would say. I would write out a proposal and then this is obviously one that I mean, you know that Olivia's not here today. That's one that has to be very closely read by an
Okay.
attorney, and you guys
Alright.
know I'm not an attorney, so I think we would be happy to
Okay.
take a proposal from you, and then we will analyze the legal implications of whatever you give us. But I appreciate, Sikander, what you said, because I do think that I think on this one, I think we might be close.
I think so too. Yeah.
And I think that that's great, because I know that this has been, obviously we have a bunch of
Dragging on,
issues,
yeah.
but this has been one of those that has been kind of dragging. So we're looking forward to maybe being able to get an agreement on this one. Any other questions about it? Any feedback regarding maybe moving that provision to 25? I mean, do you see that as a big issue? Is that something that might? be
No,
the way
I think
forward?
we're fine with that.
Okay.
Yeah.
That's, yeah, sounds good.
Thank you for that. All right. You ready to talk about Article 4? All right. So Article 4, we know that we, like I said last time, we actually had a proposal for you on Article 4, and then we didn't give it to you because you guys had proposed quite a bit in Article 4. So we went back and took what we were we had planned on proposing and tried to incorporate it into what you all had proposed. So this is a little bit longer. They are. There we go. All right, so one of the things, you already have it?
Yes.
Okay, good. So one of the things that this was really just cleanup in 4.1. We think that it was very ambiguous in the previous language to say shall be sent to the appointee within 10 days after conditions necessary for the appointment have been met. Like, we just felt that that phrase was exceptionally confusing, because who is demonstrating the responsibility for meeting those conditions? It almost is objectifying the circumstance to just be happening, like it just happens on its own. We feel it is, because this has actually come up in some of the cases we've talked about, who's responsible for demonstrating that all those requirements have been met? And we believe it needs to be clear that the applicant needs to be able to, if it's documents that need to be provided, if it's a driver's license or a social security card or, proof of whatever, like those things need to be delivered by the appointee, not by some other group. So that's all the intention is for the change there.
And I just say, we have known cases where it was administrative staff that failed to notify people about what documents were needed in sufficient time. So I don't characterize that I don't accept the characterization that it's entirely on this employee to meet conditions they may not be aware of.
Well, I think that's a different issue. Them not knowing what the conditions are is different than who's responsible for demonstrating they exist. We could add something that if that's, I think that's actually, it's connected, but I think it's a different matter.
So it's actually something we forgot to put in our last
Oh, okay.
proposal. We wanted to add something about this.
All right.
It's been a huge problem for international students,
Okay.
especially. They don't know what they need to do to be onboarded on time.
Okay.
Especially regarding what they need to do about social security numbers, Gator Star, all kinds of things like that.
Okay.
So I know of several cases personally
All
where
right.
people were not paid for several weeks in the beginning of the semester because they were not onboarded.
They were
on
late in
time. Yeah.
onboarding.
So that is something we actually forgot to put in the proposal
Okay.
last time. But
Is there a specific part of the process that has come up in more of the cases than others? Like, I know you mentioned Gator Start, and I know that
I
process can
think
be
Gator Start
confusing.
and Social Security especially are the main ones.
Okay,
Those are the ones I know just offhand from like people I know personally. But it's something that we should probably consult on a wider basis and ask.
that's
people what
fine.
they
And
think.
if that's a topic you want to have, just because I know it can be pretty specific, we may want to have a representative available maybe from the International Center, or consult with
Yeah.
Dr. Wayne and her team.
It's
to go
funny, I'm
through
actually
that.
taking a class where she's a student, so I could actually. So yeah, I can ask her directly.
Oh, that's fine. But no, I think obviously those type of bureaucratic barriers for people starting on time, that doesn't serve anybody. It doesn't serve the
Right.
university, it doesn't serve the employee. I mean,
Right.
so I think if there's an issue there that we can help address, let's do it. So, yeah, I think we'd be open to hearing more about that. But I guess to contextualize your point, I think once those statements have been explicitly made and the appointee is clear, here is your Gator Start link, this is everything that you need to do. Once that has been explicitly made, at that point, it becomes the appointee's responsibility to fulfill those requirements. And I will acknowledge that when you're dealing with a third-party service, especially a government agency, like if you're trying to wrestle with the assignment of a social security number, like that's a whole process that can be difficult in and of itself.
Right.
That really doesn't have anything to do with this, but I'll acknowledge that.
No, but
early
it's something
notification,
that they should be aware of so that
Yes.
they can get started. on it,
Correct.
you know,
No,
like,
I acknowledge that.
Cause
I
some
acknowledge
people get here and they're like, oh, I didn't realize it takes like a month
Right.
to, you know,
Yeah.
do all this.
No, I
So,
think that's fair. Like, we have more conversation about that.
Sure.
And in general, instead of he/she, can we use they?
Yes.
Sure.
It's just cleaner. It doesn't.
So
Yeah.
it's gonna show up on the grammar stuff. I mean, we can do that. Are you suggesting we make everything, I understand that. Are you
Yeah.
suggesting we make everything plural or just use the plural pronoun? Do you want me to actually rewrite the sentence as a plural?
I'm
So
just
gender
saying
neutral.
in general,
No,
yeah,
I acknowledge
Yeah.
that. I'm asking how you want me to rewrite the article.
I'm saying in general, whenever you feel like using he/she, you could just use they instead.
But not necessarily change the plurality of the sentence in general.
Yes.
Okay,
The appointee demonstrates that they meet all.
okay.
Meet does actually switch. You wouldn't
Yeah.
say they meets.
Yeah.
So the subject verb agreement, the verb does switch to plural. Like they are doing something, even if you're referring to one person.
So why wouldn't I switch it to appointees?
Yeah, I think that
You can
makes
do
it,
that.
that makes it.
Okay, that's what I
If we
realize
wanna
your point is well
make it-
taken.
yeah.
The world of grammar is changing. I just want to know
Yeah.
because I'm going to be drafting a lot of language. I just want to know what your
Right.
particular
I think we can
preferences
just say
are.
appointees.
Yeah.
that's
Okay.
Basically, just personally, I never use he/she anymore. I find a way to use they or change the subject or, I mean, the
Okay.
sentence around.
All right, so after appointees demonstrate that they meet all conditions necessary.
Yeah.
All right. All right, so down to K. And L. A website address provided, and this is kind of similar to what I had suggested for 17. A website address provided by UFFGAU that provides additional information about the organization.
So is that L or is that K?
Oh, it's showing up on mine as K.
It's there's K and then, it looks like L was crossed out.
Yeah.
Yeah, I think I was just not. actually-
Yeah.
Okay,
so it's
I'm
just
just-
K.
Yeah.
Oh, so.
Oh,
is-
it's showing up
is-
as a different color on yours. It's showing up as green.
Yeah, I think that's just because it's like someone else as
Gotcha.
opposed to
It's still
myself.
okay because they put a semicolon at the end.
Yeah.
Okay.
Yeah, it's all under K.
Okay.
That's
Yeah,
all.
it should actually be, it should just be a,
Yeah, is the
there
semicolon?
shouldn't
meant
be
to
any,
Is it supposed to be a new line? or-
yeah, so that should be
Yeah.
L. I'm sorry, Sakina, you're right. So the L should be in front of a website address.
Okay.
Okay.
That is correct. That's the intention.
Okay.
It didn't do it that way in the auto formatting of the,
Yeah, I know.
This is to your point
We know.
before, we
know
needed to
the
retype,
struggle.
yeah.
So weird. That formatting is so strange.
well, and there's a couple places in the articles where if you try to type in them, it goes to like, there's
Yeah.
Okay.
super spacing between the letters.
Yeah.
So-
Right, yeah.
Or it'll like automatically justify, or the tab will
Right.
come in 4 inches, like if
Yeah.
there's a lot of, when we get through, we'll retype it into a clean
Yeah.
file.
Mhm.
We talked about that last time. Okay, down to it did the same thing with 4.2. That should be 4.2, but it shoved the 4.2 to the end. Length of appointment. Appointments may be for any period of time up to 1 calendar year. The university recognized that year-long appointments provide job security for graduate students. We're concerned about the use of the second sentence. I think we're fine with that first one. That was your suggestion. It says when practicable, the university shall offer year-long appointments. However, nothing in this article obligates the use of when not practicable. I really don't want to be in a situation where we have to demonstrate the practicability of offering a 9-month appointment over a 12-month one. And I realize that that's a bit of a nebulous and amorphous word, almost intentionally. That may be why you picked it. I don't know, but it may be. I believe that sentence would force us, or give you the opportunity to force us to demonstrate that a choice for a 9-month versus a 12-month met some standard of practicability. And I just don't want to be in the situation of having to do that 3,800 times a semester.
The language did come directly from a different CBA. That's
I
just where
gotcha.
it came.
That's
from,
fine.
Just so you understand.
Yeah, no, I appreciate that. I just, like I said, I don't want to have to, it would just provide an opportunity to have that conversation literally thousands of times a semester. All right, down to 4.4. While an initial letter of appointment, this is not something that you had brought. This is an attempt to address some of the confusion that has existed in multiple cases since I've been here in the last year. Because again, we talked about, there's a terminology of letter of offer or initial letter of appointment, or, while an initial letter of appointment may outline the total possible years of financial support for an employee, such a letter may not make any specific promise of appointment details or assignments beyond the initial period of appointment. Because what has been at odds, I think, between, in several cases, has been, well, I got a letter of appointment. My first letter of appointment guaranteed me that I was going to be doing X or Y. And then in year 3, you made me do something else. And that violates, using your words or using somebody else's words, that's a violation of my letter of offer. So I think we have to try to, in the contract, we have to describe in a way that we all agree upon, whether it's this or something else. If there's a special standing for that initial letter, what are the parameters? What can it outline? What can it do? What can it do? Because it has to be able to square with the current language, which says nothing goes beyond a 12-month agreement. And I think that almost by definition, offering a 5-year, a 6-year letter of appointment doesn't seem to conform to that language. And I know that this has been a space that we've had a lot of conflict. So I think we need to wrestle with it. I think we need to talk about it. I think we need to figure out a way to, if we want to use a different term, that's a letter of offer versus a letter, whatever we do. I don't think anybody is served, especially their employees, by continuing to have this disagreement. I think we have to try to get it in the contract. So I don't know if you have any thoughts on that. And it doesn't have to be this, but I think we have to come to terms with, all right, how do we, because we don't want to not give people a 5-year runway.
We're open to that. I mean, the last proposal, we had proposed something about what happens if, like, the contract is abrogated.
We'll get.
Yeah, I know. Our intention wasn't for that to apply to the letter of offer, say, like, when I was accepted, I was told you get, 5 years of assistantship. That's not our expectation that, oh, they should be paid for the whole 5 years.
Yeah.
It was like more about if you have a 9-month appointment.
Right.
But I do agree that we should define the difference between a letter of offer and a letter of appointment.
I like the letter of offer.
Yeah,
I do.
and maybe that is the place to put these other things about onboarding and things like that. Trying to get that information.
Maybe we could. Yeah, I think that wouldn't necessarily be bad. I think we'd be open to that.
Okay.
So that's 4.4. If we go down to,
Oh, I have one more
Go
thought
for
on that. The use of the multi-year offer of financing, right, or appointment
Mhm.
is really important for getting competitive students. Let me say that.
Oh,
very
100%,
clearly, right?
100%,
That is a
no.
standard across the board.
we have
that-
to. No, I agree 100%.
And we need to make sure that stays valid in whatever form that it is.
It would be
Yeah.
utterly destructive to our program's ability to recruit if we don't offer a multi-year.
Yeah.
But we
it
have
has
to square that with.
Exactly.
Yeah,
but it
yeah,
has
no,
to
we can't have
hold
both
some
ways.
weight. We
Right.
can't remove all of its weight
No.
by, okay.
No, I think we're acknowledging that, and what we're saying is, okay, we're saying you have a multi-year appointment, but we're also saying that the details of that appointment after the first 12 months aren't necessarily what's in there. And I think what we've had, and not about any specific case, but there have been times that letters have been written in such a way that it was confusing to the employee,
Mhm.
where the employee felt that the letter was implying that some of the terms and conditions of either the assignment or the location or the specific work was a multi-year promise, but the contract specifically says that can't happen.
Yeah.
So I think that's where,
Yeah, no,
I think I think the overwhelming amount of interest in this is a shared interest.
I think so.
I just think we have to do better together to make it so that it's clear what our shared intention is, and then to provide good information to the grad school to help, and then also to the individual departments and colleges so that they can write letters that don't confuse their employees they're trying to attract.
Yeah.
Because the shoe is on the other foot, right? Because the interest of any employer when they're trying to recruit a hire is in one way, and then once the employee has arrived, then the relationship dramatically shifts. I mean, that's just the nature of the beast.
I completely
So
agree. I just wanted it like on the, like.
I agree.
On the table, like
I-
that's very
I don't
important.
think you're gonna get any disagreement from anybody over here. I think it's a very valid and it's a very important point for both of us.
Yeah.
So let's move on to, okay, 4.7. Man, we spent a lot of time talking about 4.7. So the university shall provide written notice to a GA whose employment unit, assignment, or supervisor changes during the appointment term. We talked a little bit last time about the fact that, if we're gonna start reissuing letters of appointment, anytime any of those things changes, I mean, there's just, the volume is just not, there's no way we could keep up with it. But I do think, and again, this doesn't have to be I'm not saying like this has to be the language, but I do think that we can probably pull out from that list in 4.1. And we talked a little bit about this last time. What are the ones that we're like, okay, look, that is so significant, that is so important, that is so fundamental to your relationship with the university. You are owed, and frankly, the university is protected by some written document or written record of the fact that, Sikander, you are no longer working for Dr. X, you are now working for Dr. Y, or you're no longer working in biology, you're now going to work in chemistry. Like there are clearly changes to an appointment at which, look, that's not just.
Need to have that in writing.
You need to have it in writing.
Yeah.
So I think that's our attempt to say, okay, of those items, we believe that those are the ones, employment unit, assignment, or supervisor, it should be in writing. Now, if you'll notice, I didn't say new letter of appointment. What I said is some sort of something in writing. I think that's our attempt to say, look, so that we can effectively communicate to and hold the individual departments and colleges accountable for saying, look, did you give it to that person in writing? Or did you just literally tell them to start reporting to a different lab? Or did you just tell them they're now working for Dr. Jones instead of Dr. Smith? Because you have to give that to them in writing so that they can feel comfortable that they are doing what you're telling them to do as part of their contract with the university. So that was our attempt there to say, look, this is when it has to be in writing. By the way, it doesn't mean that the other things wouldn't have to be in writing. Like, for example, the length of the appointment or the salary. But there are other mechanisms. I don't want you to think that I don't think that's worthy of there being official documentation, but those are provided for in another way that there would have to be documentation, if that makes sense. So that's why I didn't necessarily include those.
Right, so changes, so if there are changes to the employment unit, assignment, or supervisor, a new LOA would be issued or not?
No,
You know what I'm saying?
a written notice.
A written
In other words, we would give the employee something in writing, and it would probably be an email from the HR liaison or from their supervisor.
I am wondering why would you simply provide a written notice of changes when we are required to sign an LOA, right? And obviously, if we don't sign it, we screw ourselves, right? We kind of lose that offer. But like, this is something that it's an agreement between the department and the student when you sign an LOA.
Right.
And if you change a supervisor or a course, or these things that you're saying are really important, why is it not the same level of agreement between the department and the student?
So I would interpret that those components of the overall employment relationship do not constitute the university breaking its contract. In other words, if you are changing supervisors, I think that is something that is significant, but I don't necessarily think it represents a severance of the university's contract to the employee, in my interpretation. I don't believe.
I understand what you're saying.
Yeah.
I'm just thinking there could be a really large difference. This could be a huge difference.
I acknowledge that. I acknowledge that.
And I don't think it's a severance of the contract necessarily, but I do think it's a large change in that the student deserves the ability to have some weight in that decision.
So I think that the weight in that decision would be the employee would have an opportunity to, what available to them is that they could quit. I'm trying to think like what,
No,
to
it's
your
not
point,
great,
like
but
what,
I just feel like having a student sign it gives them some leverage in the situation, even if it's not practical,
Well,
right?
it's like an official agreement
It's an
versus
official
just being
agreement.
told, yeah, now you're working on another professor.
Exactly.
oh, okay, so to that
Yeah.
point, now I kind of see what you're saying. So I would argue that we have not waived the right to reassign your supervisor based on the construction of a letter of appointment. In other words, just because we give you a letter of appointment, it doesn't mean that the university can't subsequently decide that you are now going to go work at Dr. Jones's lab instead of Dr. Smith's lab.
There's no
Well,
bargaining
yeah.
going
Well,
on
obviously,
there.
but that wouldn't be in the letter if they want to leave. But what
No,
I,
or they leave the institution, you have a new
Yeah.
supervisor. you can assign.
Right.
do you guys understand what words I'm trying to?
I see what
Yeah,
you're,
yeah.
I understand what
Yeah,
you're
yeah.
saying.
There is a big difference, and I think just a written notice I feel like is kind of insufficient. It's not the same. And I'm not sure how you're saying that the details of the LOA aren't strictly enforceable. If you have a specific supervisor in the LOA
Mhm.
that is signed, I don't understand how changing the supervisor wouldn't be. I understand it's not a breach of the contract of employment.
Right.
Or of appointment, you still have an appointment if you get changed supervisors.
Right.
But that is a detail that's agreed upon when you sign that.
I don't disagree. So let's
Yeah.
take that, let's take your example and let's move it to the next step. Okay, so let's say the university decides that we're gonna change our supervisor. And the university states, we don't interpret that as a severance of the contract. We don't think we did anything wrong. We're moving your supervisor.
Mhm.
Okay, what is the interest of the, and I'm saying this honestly, because I want to make sure we understand it. What specific interests of the employee and which levers or mechanisms do you believe the employee should have a right to engage at that point? Because obviously they could quit, but that's not what they want to
No,
do.
that's not what. we
So
want.
do you want to make sure that they can grieve the change? I'm like, are you trying to say they can file a grievance on changing their supervisor? Because again, we're going to retreat to, that's going to be a management discretion. We have all kinds of reasons we're going to change a supervisor. So I think you're kind of looking for something in between. I guess I want to, if we can pull at that thread a little bit and help me understand what
Yeah.
is the mechanism you're trying to
Go
get?
ahead, yeah.
So I'll just say, I mean, in terms of the letter of appointment, the one that we really like absolutely need it for is the change to the stipend. Because
Mhm.
we use the letter of appointment to calculate the union deduction, like from e-dues.
Okay,
So a up-to-date letter of appointment is absolutely necessary for us to be able to calculate the right dues deduction level from our end. So for these other changes, I think, you know, we could be amenable to a different kind of written notice. But for the stipend question, we absolutely kind of really need a letter of appointment or something, you know, like a written. It could be on official letterhead, the same kind of letterhead as the letter of appointment, and it says like, this is an addendum to the letter of
and
appointment.
it can't be a report, Sikander? We can't give you a rostered report that has everybody's updated? Because that would be something that we could provide relatively easily. It's the individual letters that have to be signed that is just.
Right,
Well,
when people sign up for.
I think
e-dues, they-
for the changes to the stipend, it doesn't need to be signed. That was our initial
Yeah.
proposal was that it doesn't need to
Right.
be signed. It's just that they should receive something that can be an addendum to that initial letter of appointment.
Okay,
And so, and it should say, you know, this is an addendum to.
because what do they have to upload that during the e-dues process as an attachment? Is that what they have to do?
Yeah.
Yes, because it's been offloaded from the paycheck, right, which where it would.
Oh, no, I got- yeah, I got
So you have to self-report
Individuals-
what
your income is.
Yeah,
Yeah,
right, exactly.
yeah, that's what I was gonna say, yeah.
Okay. And we
So if
can't,
that changes, they need to manually change that in the
Right.
e-dues system.
is there a way that we can do that through Workday or not Workday through, I work here, what's the reporting system we use for income verification?
The work number?
The work number? Is there a way that we could, because that self-generates a PDF.
I think there has to be, that. That's driven by the employee. I don't know if that's something like we could, as the employer.
But the salary number comes from one of the data tables,
Yeah,
because the employee doesn't fill that in. That pulls from,
right. We're sending them reports weekly, whatever, and then you call and they give you the most up-to-date information. I don't know of how.
is that something we could ask Brent or
Yeah,
somebody else in
of
the office? Okay. Well, let us do some work on that, because if
Okay.
there's a way that we can somehow automate, if we can meet the needs of what it is you need
Right.
in a way that can get an acceptable format to you to succeed, to fill that purpose.
Right.
And take it out of this purpose, and we can, that may be a way we can do it. Let me do a little digging on that.
Okay.
I think the question is like, can we initiate that to be done?
No, they would still have to initiate it, but then we could give them and say, hey, look, when you need to get your letter that goes uploaded, and obviously we would tell you, we're not gonna tell them, you could tell them, but we could
Mhm.
show you how it works.
Mm.
And then say, look, go here, this is the work number. It'll generate the PDF that states your income, and it'll be updated based on, once the latest amount is
in the payroll, it's in the payroll system, when does it get up, like,
Yeah.
the time frame for when it gets updated? Because the last thing we want to do is give them the directions, they go in there and do that, and then it doesn't fire right, because there's a 2 week
It's
lag
a
or
week
something,
late, yeah.
you know?
Why
Alright.
can't they be pushed out by like email?
Yeah.
All the UFL emails. Why would they need to go in and like,
Because it's set up to be a self-service process. It's not set up like, it's not, it's like the supervisor can't do it. You go in and get your own.
so you don't have any like infrastructure that could automatically generate all those PDFs and send them out?
I don't
through
think
their
so.
emails?
I'm aware.
I don't think so. I'll ask.
Okay,
I
that would be
don't think so.
preferable, so.
Yeah.
No, I get that. I get that. But it's to some extent, it's like anytime else you sign it, and I realize you have an interest in making it as easy as possible. But you know, when you're having something auto deducted from any account, it becomes, at some point, the employee is gonna have to
Right.
authorize something. I mean, we can't do it on their behalf, so. All right, I'll find out what we can on that part. Okay, let's go on to 47A 1. And this is similar to the same, what we said was, in the case of a change, and this probably is, now that I understand what the reason behind you wanting this provision, this probably doesn't help. In the case of a change to the collective bargaining agreement, the parties shall meet to discuss how best to communicate the changes to all employees affected by such changes. But that would provide us an opportunity to facilitate that process if it's going to be something else. So
Mhm.
I don't think it hurts anything. All right, let's go down to B1. So this was not something, this was part of the proposal we were going to bring that you guys didn't bring up. Continued failure to perform duties as specified in the letter of appointment after written notification from the department. We would like some clarifying language. Such written notification may take the form of a letter of counseling, an improvement plan, or other such formal communication, provided that such a notification occurs at least 30 days prior to the decision to change the appointment, in order to provide the employee with a reasonable opportunity to improve to meet stated expectations. You know, our idea there was that on its own, that statement seemed a little thin. And we believe it could be improved by providing some more explicit guardrails of how it should function. To be honest, I don't think you have a lot of exposure in agreeing to that language. I think it's just more clarifying than anything else, but it's up, I mean, obviously, we just like you to consider it.
Those were helpful for someone in my position who gets these types of conversations.
All right, down to the change in C, I think, is purely a function of the other changes that were made. So that wasn't something.
Right.
That can be revised. What's the change in C is just once the references and all the auto adjustments gets fixed. All right, this was your language. If an individual receives and accepts an appointment for one or more semesters in an academic year, and the position offered and accepted is no longer available, the university will attempt to locate an alternative and comparable appointment. Now, I acknowledge that significantly guts the responsibility of the university to basically pay the person for their time. And I think we forwarded you the statute that we believe prohibits us from paying effectively severance, which is what you're kind of looking for there. But I think that's where we would feel comfortable, is we acknowledge that we will try to find them another appointment, but in terms of guaranteeing that is just not something that we feel like we're in a position to agree to. And then down to F, if an employee with a 12-month appointment requests an unpaid leave during the summer term, the university may curtail the appointment to a 9-month appointment. Now, this is what this is about. And Tom, I don't know, this was part of our conversation. We have been, at least it's been shared with me, that we have had a number of 12-month employees who systematically take the summer term off and request an unpaid leave every summer. And at that point, we don't really interpret that person as a 12-month employee. If you're going to take unpaid leave off your 12-month appointment in the summertime, you probably should be a 9-month employee. Now, it's different than what we were talking about before, whereas they have a specific reason, but this is like a systematic thing that occurs in some cases. And it's not will, we want a may. And we just like you to consider it, Tom. I don't know if you want to share anything about that, if I missed any of the points. Okay.
What are the interests in doing that? So call it a different thing rather than a 12-month employee who took unpaid leave.
I guess my question is why, if you're going to take unpaid leave every summer, why are you agreeing to be a 12-month employee?
So
Yeah,
how
I
many
just don't
summers in a row
understand.
does that have to happen for you to determine that?
We don't have it written that there would have to be any.
Okay.
I'm just saying, like, I don't understand your interest in, like, you've introduced this entire line. and
Right.
It didn't exist before, so you have some interest in like getting that in the contract. What is the interest? I don't understand.
I think the interest is that the people's contract reflects that their officially reflects their actual professional relationship with the university. I think if you're taking unpaid leave every summer, and like I said, we're happy to change this. It doesn't have to be this exact language, but if you're gonna accept a 12-month position and then ask every summer term that you don't want to work during the summer term, you shouldn't have signed up for a 12-month position because there's nothing in the contract ostensibly, at least up until this point, that says, yeah, you can take a 3-month unpaid leave every summer. Because again, the context of our leave, the
So
thing,
people request a 3-month unpaid leave?
we have cases where people they don't want to work in the summer.
Well, the max is 6 weeks currently, for unpaid
Yeah,
leave,
I
isn't it?
thought, yeah.
Well, but that's one of the reasons that we want to talk about. We want to talk about this in general because until we get the language, we've acknowledged that it hasn't been consistently applied to begin with. Right now, people don't want to take any unpaid leave, but we're letting people do it because we realize we have a problem.
Right, well, I mean, before the last agreement for Article 8 was signed, we used to
Yeah.
have unpaid leave
Yes.
instead of paid leave.
Correct.
But even then, I believe it was limited to 6 weeks, or I think it was 6 weeks at that
It
time.
was supposed to be limited to 6
Yeah,
weeks,
right,
and
right.
I'll say that as delicately as I can.
Okay,
Um, but this unpaid leave is still continuously approved though, right?
Yes,
Is, because I understand the language was it's up to the university's discretion. So I mean, if
that's a good
there
point.
was a problem
It's a good point.
with taking off the summers, then don't
Say
approve
no.
the leave.
Right.
Yeah, so that seems kind of weird to have to put that in.
That's
when
that's a
it's
valid
on the-
that's a valid point.
Yeah.
Also,
valid
I know you said you're not attached to the wording, so I don't like that. If they request an unpaid leave during summer, they can curtail it to 9 months. They might request, 3 weeks, 6 weeks, and now all of a sudden they've got a 9-month employment instead of a 12-month. So the wording is not good, but
Okay.
I know you said you're not attached to the wording. I'm
Right.
just still confused why it's like
Yeah,
something.
Yeah, they're
you're
not getting
so
paid.
interested in.
yeah. I mean, if it was paid leave then
I
that
got
would
it.
be very different. Yeah.
All right. Well, again,
Yeah.
we just ask you to consider it.
Okay.
All right. In 4.8, we would like to change the word letter to written communication. Mostly because I think practically speaking, in most of these cases, that if they're getting a letter, they're actually getting it in the form of an email. They're not really getting it in terms of like a letter that's like mailed to them physically. So
Right.
I don't think that that's really a fundamental. I think it's just really just cleaning up our practice, but we'd like you to consider that. And then 4.9, we spent a very significant amount talking about 4.9. And the reason we want to talk about 4.9 is because, again, this is kind of like the unpaid leave thing where we believe that the practice is relatively scattered.
Mhm.
And I think that enforcing this language as it was previously written, I don't think it necessarily serves either of us terribly well by constricting who can get a summer appointment and who can't get a summer appointment. I think there may have been cases where doing it this way, but I'll be honest, I'm not 100% certain that this was effectively consistently applied the way it was written to begin with. And I don't think that the employees would have raised their hand because if they had the opportunity to be appointed for a summer term, they're not going to report themselves that they shouldn't have been had an opportunity to work.
Mhm.
Does that make sense?
Right.
I just think that if someone's on a 9-month appointment and there's an opportunity for them to work in the summer and the department or the division or the program wants them to work and they want to work, why would we prohibit their ability to get an additional appointment? I'm just left somewhat wondering. I'm sure there was a purpose. I absolutely am 100% certain that there was a reason we had this written that way. And I spent
Yeah.
significant time talking to Tom and Judy and to HR about it, but I don't have the fundamental history on this. But I am just worried that I'm worried that we may have offered 9-month RAs an opportunity to teach in the summer, and I'm not sure if we want to offer a 9-month RA an additional 3-month appointment, why we would not want to do that. If they want to work and we want them to work, why would the contract prevent them from doing it?
Sure.
Does that make sense?
Yeah, no, that makes sense. I'm not sure, I'm just not
I'm just trying to figure out how that wording like really.
It was,
Yeah.
I found it to be very
It is.
confusing.
Yeah,
I mean,
that's
here,
it.
if you want the original, if you want to read it, because I know the crossouts make it confusing, it's here. There's the original.
Thank you.
And maybe I'm just maybe we as a team are just interpreting it completely wrong.
Yeah, I actually, yeah. When we were reading it, I also found it weird that it specifically says summer RA appointment because, I mean, I'm on 9 month and I used to get
Yeah.
summer TA. appointment.
Okay, it sounds,
So,
I think what it was trying to fix was that people that pretty much do TA for their entire 9 month appointment, but there's not a TA position
It wasn't a
available over the
class to
summer,
teach, an
that that they would allow them to do, instead of doing TA over the summer, they can then do RA, that's doing research over the summer, but since it's already a 9 month contract, it would be, yeah, I guess, yeah, there's some confusion.
So it seemed to me, it seemed to imply that teaching assistants couldn't do that. Because why would you say that it's allowable for RAs? Because it implies then that TAs can't.
Well, I think it's,
No, I think
it's a
it's
summer
implying that-
RA appointment for people who are TAs, but
Right.
cannot TA over the summer. I think
Right.
that's the point I was
Yeah,
trying
and
to
I
get
think
across.
the origin was you'd have department chairs who didn't have a class to offer.
Right.
For them to be a TA in, and so it's like, can we give them an RA then if there's not? a
Yeah,
class?
but I
If
don't
there's-
see
if there's
why
no
that would have been an
enrollment
issue
event for the
already.
point of Summer.
The point stands, like,
Yeah.
they got too specific to address a very specific issue, but
Right.
we could broaden the language and it doesn't. fit in.
Yeah,
Yeah, because I think if we were to just remove the provision entirely, like, let's say we had nothing, I don't think there's anything otherwhere in the
Yeah, but
contract
it's-
that
but it
would say that
specifically
we
says
couldn't
9 months.
extend to someone additional.
Yeah.
But I think because it was already in there, I would rather clarify it and make it clear that you can just
Yeah.
kind of do it.
Mhm.
And like I said, I don't think either of us have a lot of exposure in that. I think it just broadens who can. Unless you are aware that there is a specific group of people that fit that requirement that needs some sort of like first bite at the apple, but we couldn't identify who that category of people would be. So,
Yeah, that is, it is a little bit confusing. I think it may be that there might have just been some issues with this. Maybe just people not getting appointments that they needed, so we needed to force those appointments, I guess.
that, I think that may be right.
Yeah.
But when we looked at it, we couldn't, again, we're not aware of. Again, it doesn't seem consistent with the GAU's interest to want to say this particular group of people are given a preferential placement or a preferential hiring over these other members. I don't think that's necessarily consistent. It certainly wouldn't be in our interest, but I don't think it's consistent with your interest elsewhere in the contract, so. All right, that's,
okay, so if we could just return to this one,
Which
which
one?
I suppose is C now, or is it D? I think
Under-
if an individual receives an exception.
oh, okay, yeah.
I think it's supposed to be D.
Yeah,
It's
okay.
supposed to be D.
So, yeah, I mean, do you mind going through the statute and telling us exactly which part prevents you from providing
Yeah,
severance?
because it seems like from what you sent us.
I'll just throw it up on
Yeah.
the screen as well.
I think it was just really the issue with severance, or being considered severance,
Right.
when I don't think it was our intention for it to be considered severance.
What do you consider it to be?
Sorry, yeah.
No, I mean, I think that's important. And unfortunately, I'm gonna acknowledge you have me at a disadvantage. This was something that Olivia presented to me. So I will do my best to answer your question, but I'm gonna defer to her legal expertise on interpreting the statute. So please just, again, I've told you
Yeah.
many times, not an attorney.
Yeah, no, yeah, neither are we. So, yeah.
So I think that, oh, you got it pulled up there. So,
Cause I'll just tell you what the part
Go
that
ahead.
we kind of honed in
Yeah.
on, was this part, right? Basically on blah, 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 if a unit of government enters into a agreement that contains a provision for severance pay, a requirement that severance pay, provided may not exceed an amount greater than 20 weeks of compensation. So from our perspective, that seems to mean that you can have severance pay and it can be for up to 20 weeks.
I think it's actually farther down.
Okay.
Hang on. What's in B, on or after July 1, officer which kind of may receive severance pay that is not provided for in a contract. The severance pay represents settlement of an opinion dispute. The such pay may not exceed an amount any greater than 6 weeks of compensation. Settlement may not include provisions that limit the ability of any present someone to discuss or dispute the settlement. I'm not trying to avoid your question, but unfortunately, I'm gonna have to defer to Olivia. I apologize.
okay.
And I'm sorry she can't be here today.
That's all right. I mean,
I'm not an expert on this part of the law.
if you could like tell her to tell us her interpretation.
Absolutely. Well, I think she'll be here next week, so she can.
Sure, I mean,
With you.
okay, so then we can
I
give a counter
apologize.
proposal
Yeah.
after we
Okay.
hear about that.
Yeah.
I may be able to provide it to you in writing in the meantime.
Yeah, that's what I'm
Um,
saying. So if
yeah.
you can do that, that would be great as well.
Was that your only concern? Was this legal for changing? this,
That's what she present, I mean, I'll just be very honest, that's
Okay,
what she
that's
explained and
all.
presented to me,
Okay.
but there may be other components, but that was the primary reason.
Okay. Okay.
That when we spoke about it.
I think what I'm grasping at is the distinction and the definition of this being severance pay.
Yeah,
I
so,
think that's what's holding me up on it.
yeah, so that's what I mentioned before. I think our intentions were, we weren't really asking, okay, we want severance pay if the contract can't be held. We
Right.
want just a guarantee that we can just have some type of other appointment or work, or like there's something else in lieu of the contract, or, if whatever happens, it gets eliminated. I think that was the intention, not really just to.
And it doesn't have
like
to be
laid off
necessarily
or
in the same
severance.
department.
Right,
It
right.
could be like maybe
It's-
just a general GA
So-
appointment under the grad
Yeah,
school or something
yeah.
like that, you know.
But that was the intention, not really
I
severance.
think that's a good point. I think one of the things that I struggled with, the statute notwithstanding,
Sure,
is how that situation would conform with 47A4. Because
or B4 now.
yeah, now it would be B4. When there's a lack of funds as a result of adverse conditions,
Mhm.
because in those situations, we have to provide 3 weeks notice.
Right.
I think, and I don't know this to be a fact, but I think in most cases, the reason that an appointment that previously was offered and then is withdrawn is for financial reasons. I don't think it's because, or there's an employment reason, or the student doesn't join the program, or I think there's a bunch of things that would preclude any of this from coming into play. At which point I think that would be the governing provision. Because let's say,
It says
Well,
lack
so-
of funds as a result of adverse financial conditions. though.
Right.
Like, that's not necessarily, we thought we had a GA ship. Now we're spending the money on something else. That might be lack of funds, but are you gonna say that the only time a GA ship would go away is that department experienced adverse financial conditions?
well, I think that, yeah, absolutely. I mean, I'm not saying it's the only reason, but I think it's the prevailing one. Because here's what I know you had said that there was a bunch of or there were at least several cases that you all had brought. Again, I'm not necessarily familiar with those specific situations, but I'm finding it hard to believe that if a faculty member or a chair who is going to have access to support and help and employment of a GA, they would just sort of arbitrarily or flippantly decide that all of a sudden they didn't want them anymore. So I'm trying to figure out like what would be the driving force in the making that decision of saying, I had these folks coming, but now I'm deciding that I don't want them to come.
It's like any type of reason could be. Adverse financial is only one in a whole.
Yeah, the funds could be spent in a different way. And
Right.
Be structural.
so, I mean, the other thing is like, I mean, it could be that a particular department is facing adverse financial conditions, but the university as a whole might not be.
Right.
So again, what I was saying before about, having a different kind of GA appointment under the grad school, for example, or something like that, like where, a different pot of money is being used to ensure
Right.
that this person is not like having no pay at all.
Yeah.
For,
Right. Yeah, I got that.
Yeah.
I think that would be a different type of very problematic thing for us to agree to, because in that moment, you would basically be forcing one department to spend money on behalf of someone else who didn't want to spend it anymore. And I'm not sure how to square and basically force the fungibility of operational funds. Because let's say, if the history department offers a job and then they pull back on it and say, well, okay, now they have to go work in the sociology department. So somebody is gonna have to, not them, but somebody is gonna have to foot the bill in another department. I think that would be very, very problematic.
Is there like any kind of fund at like the graduate school level that could?
I would defer to Tom.
Could pay for a DA appointment?
Yeah, we just get the pass through provost office
Right.
essentially. It goes to the colleges, so it could be within, I mean, I think that fungibility would probably be within colleges and their budget.
Do we have a sense of the scope? Because I have no idea of the scope. Like, are we talking about 3 people? Are we talking about 30 people? Are we talking about
Yeah.
300 people? Like,
I think it's more on the order of 3,
okay.
but we have no numbers to back that up.
Is there-
Like,
is there-
We just don't see it super often, but again, it's like
Right.
one of those things that.
If you would be willing to maybe, if we could sort of dive into those specific cases a little bit more and
Mhm.
find out and maybe pull back the curtains of exactly how it, like, what was the dynamic? What was the underlying reason? Maybe we can attack it from a different way.
Okay,
I think a comprehensive guarantee that we're gonna put them somewhere else and make it work is probably unlikely that we're gonna agree to that. But that doesn't mean that we can't look at those situations and prevent them a different way, if that makes sense.
Mhm.
Because I appreciate that there is we don't want to be pulling the rug out from under people. If they're coming here ostensibly under a certain set of conditions or promises, and then at the last minute they get button hooked and now they don't have anything to support them.
Right.
They've made decisions to move here.
Right.
That is a valid concern and interest, and I don't think they need some level of protection.
Mhm.
So let's take a look at if you would be okay with maybe digging a little bit, and if you're comfortable sharing more about those cases, and let's talk about if there's another way to maybe provide them some protection.
Last time you had also mentioned that you were open to kind of increasing the notice period for, notifying people about when their appointment has been curtailed or diminished.
Yeah, I think we would we would be willing to hear a proposal on that.
Okay. Any other questions, Naj?
I mean, if you can see, I added one we added one on ours just in one because we believe that, again, explicit rules, as Robert will tell you, explicit rules about this stuff is just as helpful for us as it is for you.
Mhm, mhm. Any further questions, Hannah?
Thinking.
I don't think so.
Okay.
I think it was Ava who had those examples.
Okay.
Yeah.
We'd like to talk we'd be willing to talk more about it and see if we
Okay.
can. Well, I appreciate you gave us 90 minutes to present our stuff. Do you guys have any that you're interested in presenting today or no?
No, as I said last time, I think we'll
Okay.
save it for next time.
All right,
Yeah.
if you wouldn't mind then, before we wrap up, do you have any, if we could just talk about this? Is there any that you plan on bringing so that, again, what doesn't happen happened last time, meaning if we both prepare a proposal in the same one, if we're planning on workshopping
right.
it together, that can be
Yeah.
good. If we both know we're doing it, or do you want to take some and we can take some so that we sort of each start and then we can pass? I mean, I'm happy to do it either way, but do you guys want to talk about that a little bit?
It's a bit hard for us to make that decision right now.
Yeah,
I think, could we tell you?
Sure.
Yeah, I could send you an email like early next
Well,
week.
even just in general, do you think it would be valuable if it doesn't have to be for all of them, for an article, if we both prepared and say, hey, look, we want to dig into a particular article next week, we'll prepare what we want to do and maybe we can work on it at the same time? Or is this better where we just kind of pass and then we go back? I've done it both ways. Both ways can be good. Do you have a preference?
Wait, sorry, what was the first option?
So sometimes we say, look, hey, next time we're going to talk about Article 7.
Okay,
So we're going to prepare what we want and you're going to prepare what you want. And then we get together and sort of dig in and we work on it at the same time, or we don't have to do that. It's
Yeah,
one
yeah.
way. Or do we want to be like, no, we're going to take these 5 and you take these 5, you start and then we'll pass.
Maybe the workshop can work for some of the articles where we're mostly agreeable on, but I feel like the ones that we are not, it'd probably be better to go back.
Okay.
yeah,
I mean,
That's fine.
because there's gonna be so much to talk about, and then we need to also probably
Sure.
to go and discuss.
but
this.
yeah, maybe some of these ones where we kind of have more agreement on,
Okay.
then we could
Okay.
tell you.
It'll probably go faster,
Okay.
this workshopping together.
All right.
Oh, yeah, well,
Shoot me
I'll
an email.
email you early next week.
And if I can get with Olivia to sort of talk about that.
Yeah, that would be great.
Beforehand,
That
that
would
way
be
we don't
great.
have to wait and you guys can take it, consider it in the meantime.
Sure, yeah.
Not that she's gonna be bargaining with you over email, but she's gonna be providing you answers to your questions.
I understand,
Yeah,
yeah,
okay,
thank
that's
you.
fine.
When are we gonna get new printed copies of the CBA?
So I think the question is, do you want the ones now, or do you want to wait until between the ratification and the full book, do you want me to get you guys a copy? That's the question. And I mean, I can,
The ratification of Article 10.
right? Do you want me to get you an interim, because it's gonna be, I mean, it's fine, but it's probably gonna be outdated almost immediately because we're already in it. I'm happy to do it.
I was being optimistic to think that Article 10 is gonna be ratified very, very shortly.
I think it's gonna be, I think it's gonna be verified before we're done with open book.
Well, that could be a while,
That's
right?
a long
Yeah.
time.
Yeah.
Right, that's why I'm happy to do that. We'll get,
No, I'm just saying, I accepted that we wouldn't have the open book changes in the new printed, but I figured at least Article 10 would be ratified very shortly. Now it's been like a month,
right,
and we could get the printed ones pretty much immediately after that.
we can, as soon as it's, I mean, here's what I'll do. I will plan on as soon as it's ratified, I'll work with the office to put in an order for it right away.
Well, I guess well, I don't know though, if it's ending up gonna be like close to the end of full book, maybe we should talk about it.
I don't think it's going, that's what I'm saying, is I don't think it's going to be. I think
Okay,
there's gonna be a
okay.
significant amount of time that passes between Article 10 being ratified and us being done with full book. I think that's gonna be a significant amount of time.
Okay.
That's what I was saying.
Then I think it's worth having the updated one.
With the new Article
With the
10.
new
Yeah,
Article
so
10,
if-
and
if-
the change to
8,
8,
as it stands now.
yeah.
So if you would just do
But
the,
if we could get tentative, oh, no, that wouldn't work. Never mind. Okay, yeah.
yeah, we can't do a partial
Yeah,
ratification.
yeah,
So if you would just, I sent you a couple different versions. If you
Mhm.
could just be sure, the one that you give the thumbs up to, just email it back to me and say, we agree this is the one, because the last thing I want to do is put in an order for the contract and then it be the wrong, it be
Oh,
not
yeah,
the
yeah.
one, and then we've got
Yeah, we'll do that.
a bunch of copies of
The wrong-
that just
yeah.
get circularly filed.
Yeah,
How
no.
do we get
we'll
ones
check
looking like those Bibles?
that. Yeah, what?
I've never put in an order form
Yeah,
before, so I
right.
honestly don't know. I will find out.
Let's
Yeah,
put that-
that's a nice, I know you.
But this didn't come in them, that I put that stuff in there. They don't come like
The
that.
gold lettering.
Yeah. All right, well, thank you very much.
Yeah, thank you.
This was again, I think this was another productive session.
I agree.
Sikander on 11,
Mhm.
I'm trying to track down some data on that.
Okay.
If you have any cases, ones where you know the department was asking for more,
Mhm.
send them to me, because I want to
Okay.
make sure I'm capturing those in the research I'm doing.
Yeah, thanks for bringing that up, Tom. I meant to explain why we haven't had a chance to respond to that one. It's because we're trying to do financial analysis on our side
Yeah.
to figure out which programs would be sort of quote unquote on the hook for having to pay the difference. So we're
Ask for some
analyzing.
data, people who are registered for more credits than are covered.
Okay.
But I'm trying to figure out which ones their programs would have required it. So I'm trying to get a couple of
Okay.
examples. I can see if we're at least capturing them in the right group. Thank you.
They'll have a good weekend.
I know of some examples where the department is already covering the extra requirement.
Okay. Yeah, a lot of them with fellowship, like Judy was saying, it's one. Fellowships and stuff.
Right.
I don't know how to distinguish all those in the database.
Yeah, and I think Cassie was saying that she, in her department, it might require her.
I
to do
believe.
that. Yeah.
She may have, yeah. We have examples where it's not being paid, but I do also have
And they're
examples.
requiring it.
Yes,
Yeah,
but I do
that's
have
what I'm-
examples where it's required and paid. Like the
Okay,
department's
okay.
already doing it too, if you
Okay.
want any of those.
Yeah, I mean, send it, the more I have, the
Sure,
more I
yeah.
can
We
analyze,
can do that.
that'd be good. Thank you.
Okay, sweet.
Nice weekend.
And you too.
Thanks.
Yeah, my
So-
first request of that, I had a momentary freak out because it showed all these students registered for 24 credits.
Oh, wow.
And in particular colleges, showed this to the dean. I was going,
Like for
we
the,
realized they had Had two different appointments, so it was double counting. I
Oh,
was like, okay.
So should we move to the debrief room? There's only 3 people, so I think we can just stop recording and make.
And one is you.
Huh?
And one is you.
Yeah, one of them is me, yeah.
Let's take like a 2 3 minute